In this video, I want to talk about why you have to make a plea of guilty or not guilty in regards to a citation. The simple reason is that the magistrate is in a jam. He has no standing to hear the case, and the police officer filed counterfeit and fraudulent paperwork. So when you go in to make a plea, you're granting the magistrate permission to hear the case, and you're legitimizing the paperwork filed by the police officer. Now, I'm from the Commonwealth of Pennsylvania, and this information might apply to other states because the word defendant is used in the pre-printed wording on these citations. In some states, the word defendant is used in the verity statement. When a police officer signs the citation, he has to make this verity statement, unsworn falsifications to authorities. Now, you see, no plea should be necessary. In fact, they should schedule a hearing automatically. And why is that? Because you're already classified as a defendant. During the vehicle stop, at that point in time, you're the accused. The police officer is making an allegation that he saw you do something wrong. So that means he's alleging that you were the offender. And as the offender, if you went to the magistrate's office to enter a plea of not guilty, then at that point in time, you become the defender or the defendant. But if they already have you classified as a defendant on the citation, then no plea is necessary. So this is where they're in a catch-22. They're in a jam. Now that is like, you want to throw some rocks in their gearbox? So when you go to the magistrate's office, you're not going to talk to the magistrate directly. You're going to talk to someone in his clerical staff, usually a secretary. And concerning the citation, you're never issued a citation. You're issued an uncontrolled copy of a citation. After the police officer fills it out, he might let you look at the original. He might even let you hold it for a minute because he wants you to sign it. And then he takes it right back and he just gives you an uncontrolled copy. So technically, you're never issued a citation, only an uncontrolled copy. And on this uncontrolled copy, the lower portion is like a coupon. For example, if you decide to plead guilty, you fill out this coupon, you detach it from the uncontrolled copy, and then you put it in an envelope, and then you attach your money order with the amount, and it's a done deal. But this ritual of saying that you need to make a plea of guilty or not guilty, that's a scam. Because they already have you listed as a defendant on the citation. You see, words and phrases are often time sensitive. One example I have is that when a woman gets pregnant, and what starts growing in her womb, at that point it's called an embryo and then a fetus. And after the gestation process is completed, usually at 9 months, then the word fetus is no longer used, and we start using a new word called a baby or a child. Yes, words are often time sensitive. So now, technically, you don't become the defendant until you declare that you're going to defend yourself. That means you're going to raise a dispute, you're challenging the allegation. So if they already have you named as a defendant on the citation, then they waive the formality of you making a plea. In fact, they entered a plea of not guilty on your behalf. That's the only way they can list you as a defendant on the citation. So now, but they need you to make that plea to give the magistrate standing to hear the case, and you want to, and for you to legitimize this bogus and counterfeit paperwork filed by the police officer. So to me, the citation business, it's a minefield of deception. I mentioned that in one other video. So I can't stress that enough. For you to be classified as a defendant, that means by them, they made the declaration that you're a defendant, because the word's on the citation. That means that they waived the formality of you making a plea. That means that they entered a plea of not guilty on your behalf. That's the only way they can name you as a defendant. Now, I realize in legal land, words are bastardized. For example, the word driver. They want to use the word driver to mean anyone operating a vehicle. A driver is a commercial operator. If you're going down the road, you're just traveling, you're an operator. That's it. You're a motorist operating a vehicle. Okay. So, when you go to this window, so like I said, you have 5 days. They expect you to make your plea. You're not going to talk to the magistrate directly. Like I said, you're going to talk to one of his clerical staff, usually a secretary. Now, these people in the clerical staff, they have no clue what the law is. Some are just happy to have a job. And there's a lot of nepotism going on in the court system. They try to hide the nepotism, like the magistrate, he'll have his brother hired, maybe with some other magistrate 20 miles down the road, or in the some other government office. But if there was an audit done to see how many government officials there are in a given municipality, and how many are related to each other. Okay. So these secretaries, they're like the Barbie doll with the pull string. And the only written information they have concerning their protocol, their procedure. They might have some internal policy statements in the magistrate's office, maybe a memo posted on the bulletin board. That's all they know. Plus, they're not going to ask questions. They're just going to do what they're told. So if you walk up to the window and you tell this secretary, it says, hey, I don't need a plea. The state already entered a plea of not guilty for me because I'm already listed as a defendant. In fact, I don't even have to request a hearing. One should be scheduled automatically. She's going to have the deer in the headlight look. And she's going to say, well, oh no, you have to sign, you have to tear off that coupon and fill out and hand it to me. You have to make a plea. I said, well, if you want me to tear off this coupon and submit it to you, what law? Could you cite the law? They don't know the question. So they're going to pull that string and say, well, sir, if you need legal advice, you're going to have to go see an attorney. Well, I'm not asking for legal advice. I'm asking for legal intent. And then, as a tactical swing move, I'll tell the secretary, you know what, miss, I think you're incompetent. You don't have a clue what's going on here. Get someone that by the window that is competent. So this is when she'll usually go run into the magistrate in his private office, Let's say, hey, I got a problem. So the magistrate's going to come out. That's what I want. I want to talk to him, not one of his flunkies. So now I'm going to tell him, I said, I don't have to make a plea. The state waived that formality. They made a plea of not guilty. They already made a plea of not guilty on my behalf. That's why they have me listed as a defendant on the citation. That means I don't even need to request a hearing. One should be scheduled automatically. So now, in Pennsylvania, in the vehicle code, there's no definition for a defendant in section 102. I recommend people that you get a copy of the vehicle code for your state, and you get it in a PDF format. And then when you open it on Adobe, then you can do a word search. So if you want to do a word search and see how many times a word is used, like I said, you get a copy in PDF format. It's real easy, like I said, to do word searches. So now, I said, the magistrate says, hey, I take the word defendant at face value. It's one that is defending. And a person isn't defending until they make a declaration that they are defending. So if you have me listed as a defendant, then that means the state already entered a plea of not guilty for me. Think about it. Excuse me. Now these magistrates, they're trained in psychology. They're masters of distraction and intimidation. They want to disarm you. They want you to second guess your position. So he might say, oh, well, that word defendant, that's the same as someone that's accused. I says, no, show me that. What definition is that? I said, what dictionary are you using? A cheap dictionary from the dollar store? I says, what's the definition in the vehicle code? Go find it. If he does look, he's going to be in for a surprise because there's no definition listed. I don't know. To me, you can't be called a husband until you get married. Before you get married, you might be the fiancé. Once you get married, then the name changes. Well, same thing. During the vehicle stop, at that point in time, you're the accused. You're the offender. The officer is alleging that you, violated some section of something. And I guess they want to bastardize the word defendant. It's made out of rubber. They could, well, said words and phrases are time sensitive. Now, if this magistrate or the secretary insists that you must, fill out and file that, submit that coupon, they'll use intimidation. They says you don't make a plea and submit that coupon, then you're going to be found guilty by default, and you could lose your license and there'll be points. So they want to intimidate you. And so, like I said, depending on the situation, I tell people to detach that coupon. You fill it out, and you sign your name, agent of, and then you sign on under duress and coercion. Because if you do not submit that guilty plea voluntarily, it means nothing. It's like the magistrate's holding a gun to your head. You're under duress. Here, sign this check. You owe me $50 million. So if you sign under duress, it's like you didn't sign it at all. And see, they screwed up. On a citation, you should be named as the alleged violator, the accused, not the defendant. That's putting that word on it is premature, but hey, you could use that to your advantage. Can't stress enough. If they're going to classify you as a defendant, that means that they had to waive the formality of you making a plea. They entered a plea of not guilty on your behalf. That's the only way that they can classify you as a defendant. And that means that they went that far, then they should automatically schedule a hearing. Not you. But they need you to submit that coupon and enter a plea because they're in a jam. The magistrate can't do anything with fraudulent and counterfeit paperwork. So, by you making a plea, you are granting him permission to hear the case, and you're also legitimizing this bullshit paperwork that the police officer filed. Now I'm going to do a sequel to this video of a lot of other things that take place here. But for now, I have a couple other things I want to mention in this video. But to recap so far, see, hidden in plain sight is that word defendant. It's on the citation. You could, now, that word has a lot of power. That word is like a big rock in their gearbox. It's time to use it. Because their system is all about money. It's a big money game. Okay. What else can I mention in this video? Okay, see, my videos are directed to the average motorist. Someone that just wants to go about their business, maybe do some shopping, you know, go to a doctor's appointment, maybe go out to dinner, take the kids to some activity, and then come home. One threat a motorist has here in the Commonwealth of Pennsylvania is the condition of the roads. They're terrible, infested with potholes. I told this one state senator, I said, hey, you should disband the Pothole Preservation Committee. But the biggest threat to a motorist is some police officer in panic mode that he has to go and meet his quota for the end of the month or the end of the quarter. So he's going to, you know, start pulling people over for any excuse because he needs some fast money in a big hurry. Now I realize that the police, they're going to deny that there's a quota system. Yeah, baloney. So how could you prove or disprove if there is a quota system? By examining the data and checking for patterns. They can't hide that. Now all these citations, they have sequential numbers. So you get all the information that is on a citation. You like start putting it on a spreadsheet, and you check for patterns. How many citations were filed each month, each week? Especially, you know, is there peak periods? As an example, how do you think a police officer gets a promotion or a pay raise? By his productivity. The police have to debase themselves, and they have to become the hunter-gatherers, and they have to go out there and collect the berries. Every, you know, they have to collect so many berries every month or every quarter. Yes, they can't hide the data that's in the reports. Yeah, like this one police officer. 3 weeks before he got his promotion and his pay raise, within a 3-day period, he issued 135 citations and brought in a total of $29,285. That's some productivity. It's all about money. See, between the police and the magistrate, the courts, it's a for-profit industry. Even the magistrates are on a quota system. Now, speaking of magistrates, see, if I get a citation, or you get a citation, the first thing I do, or I tell you you should do, is, well, I go up to the courthouse, I go into the Befonetary's office, and I get a certified copy of this magistrate's oath of office and his bond. And these guys are bonded. I mean, they took an oath to support and defend the Constitution. Well, checking this paperwork, I was surprised to see that a lot of these magistrates, their paperwork is defective. They got dates missing, signatures missing, bonds that are expired. Another thing you find out on this paperwork is it marks down if they're appointed or they're elected. Now, here in the Commonwealth of Pennsylvania, more and more of these magistrates are being appointed. And they're getting a nice salary. They're getting a six-figure salary, about $150,000 a year. I think in Philadelphia it's up to like $174,000. So that means if they're appointed, that means they're pre-groomed. They know that they're going to play ball. It says, here, we're going to give you a nice salary, and you're going to play ball. You're going to help us rake in the money. If not, you're going to be fired, or we're going to replace you with someone else that will play ball. So anyway, if I go to the courthouse and I find out that this magistrate was appointed, to me, he's acting under duress. So I put a motion to dismiss him because he's appointed. I want some magistrate that's elected that, you know, that they're accountable to the people, not to their cronies. Anyway, so after I go up to the courthouse and I get a copy of this magistrate's oath of office and his bond, I go home and I type up an affidavit and an interrogatory. Now, interrogatory is just a fancy name for a list of questions. The interrogatory I have has at least 22 questions. So while I'm at the magistrate's office and we're arguing over why I have to submit this coupon, I can tell people, I says, if push comes to shove, you just take that coupon, you put down not guilty, you sign it, you know, agent of, under duress and coercion, and you submit. Here it is. You slide it under the window. Once it's on their side of the fence, that's it. Too bad. Because you tell them, I said, don't have to make a plea. The state made a plea of not guilty on my behalf. That's why they have me listed as a defendant on the paperwork. It's not my problem they screwed up. You could use that to their advantage. Throw a rock in their gearbox. Anyway, I tell this magistrate, I says, well, if you want me to submit this coupon and plead not guilty, that means that you want me to grant you permission to hear the case and legitimize this paperwork filed by the police officer. Well, then I want you to sign this affidavit and I want you to answer the questions in this interrogatory. See, in Pennsylvania, the magistrate is not a court of record. So I want proof that this magistrate is going to honor his oath, support and defend the Constitution during the hearing. See, I call it the tit-for-tat rule. If they expect you to go to court, you got to raise your hand and say, I swear to tell the truth and all that stuff. Well, then, I expect the magistrate to raise his hand, so to speak, and say, hey, I'm going to support and defend the Constitution during this hearing. See, that's only fair and it's only reasonable. Tit for tat. Now, some of the questions that I have in the interrogatory, I mean, hey, I think I'm entitled to a fair hearing like everybody else. You're entitled to a fair hearing. So one of the questions in the interrogatory is, I want to know if this magistrate is related to this officer by blood or marriage. You know, is he a cousin, a brother? I don't know. Another one, this will piss him off. I'm going to tell him, I says, hey, I want to know if the magistrate and this police officer are lovers. You know, maybe they belong to the same, you know, bunch of swingers. So, hey, the way things are today, anything's possible. But if this magistrate has an intimate relationship with this officer, I want him to recuse himself. And if the magistrate does recuse himself, well, what reason is he going to give? He has to give a reason, I think. I said there's at least 22 questions. I could talk about that in another video. Like I said, this is just like a summary and like an overview. I just wanted to get this video uploaded. Oh, I'm sure you know the routine. You go to court, everybody's already seated, and who's the last one to enter? The magistrate and his entourage, you know, usually his secretary. And then what happens? Everybody has to rise on their feet, stand at attention as he walks in. That's not a harmless ritual, you know, to show respect. They need you to stand so Scotty can beam you on board. That court of his, it's not just a room, that's a ship and dry dock, a foreign vessel under the control of a private corporation known as the Bar Association. And that acronym stands for the British Accredited Registry, which is a subdivision of that other corporation called the City of London. That court that he's running is under the control of a foreign power. We've been under occupation since 1933. That's why the infrastructure in this country is terrible, because these bastards, they collect all this money and they stuff their pockets. I mean, they came here, they infiltrated and have taken over government. They've infiltrated and taken over government just to stuff their pockets. So now, you know, we don't have a government anymore. We have a de facto government. Stop and think about it. That Bar Association has infiltrated and taken over the judicial branch of government. Now they've infiltrated and taken over the other two branches of government, the legislative and the executive. I did some research, and it seems at last count at least 67% of officials in Harrisburg, either elected or appointed, are also members of the bar. It gets to a point that some mayor from some municipality, he won't even try and wipe his ass without asking the solicitor, hey, is it okay we could do this? So who's really in charge? To me, the Bar Association is a twin sister to that Catholic Church, which I call the Vatican Corporation. Yes, twin sisters. They have the same rituals, the same titles of nobility, their use of Latin. They bastardize the language, and can't forget their costumes. I mean, I call the magistrate, he's the magi. I just focus on the prefix of his word. I mean, he walks around with that black cape of a magician. There's something wrong with these guys. Why do you need a title of nobility and you're walking around with some inquisitional costume from the 14th century? Something wrong there. But they need these stage props for control. And they try and control you through manipulation, through visual effects. But that only works if you're ignorant. I keep stressing, you have to go see that movie, The Wizard of Oz. The last scene when Dorothy and her friends are standing before that holographic image in the pyrotechnic display. Then little dog Toto goes over and pulls open the curtain. And he reveals the scam artist pulling the levers. Well, once this wizard was revealed as a scam artist, Dorothy and her friends weren't afraid anymore. They realized that that was just hocus pocus visual effects. That's why they need you to be ignorant, because ignorance, then comes fear, and then they can control you through your fear. Oh yeah, they getting back to that secretary. She's like the Barbie doll with the pull string. Yeah, she wants you to go see an attorney because he has a vested interest to protect the scam. You know, he's a card-carrying, dues-paying member of the society known as the Bar Association. And he wants to get people on this ship and dry dock, this foreign vessel, because he's going to make money. How many lawyers that you know that are not millionaires? Yes, these lawyers are not going to piss in their own pot of stew. They have a good racket going. Now, a lawyer might defend you. The more money you give them, the better the defense. But to a point, there's a line in the sand. He will not jeopardize the racket. He's there to protect the racket. That's why the secretary wants you to go see him. Lawyer's not going to be telling you things like I'm telling you in this video. To me, the lawyers know that the police officer has filed counterfeit and fraudulent paperwork. But he's not going to tell you, oh, well, you're already named as a defendant. You don't have to make a plea. Let me continue here. Just checking my notes. Yes, that citation, it's a minefield of deception. Another thing too, see my game plan, my strategy, if these guys are trying to get like $300 from me, I want them to spend $3,000. If they think this hearing is going to last about 15 minutes, it might take 15 days. I want to disrupt their profit-loss ratios. Oh, another thing too, before I forget, I said this is only a summary. I want to do a more detailed video. Now in Pennsylvania, they automatically list the Commonwealth of Pennsylvania as the plaintiff. Well, first of all, which one are they talking about? Are they talking about a geographical land area, or are they talking about the entity of fiction, you know, like the state government? I'm sure the police officer isn't going to walk into dirt with a bucket full of dirt and say, here's the plaintiff. So what I do is I say, hey, I want to subpoena the plaintiff. And this is when I don't mind tipping my hand because it has proved advantageous for me. See, I want to subpoena this person. See, in legal land, an entity of fiction is defined as a person. So this person, this Commonwealth of Pennsylvania, I want to subpoena that person to come and testify. And that means that its agent, its authorized agent, usually someone from the Attorney General's office or the local district attorney's office, has to come and make appearance. The main question that I want to ask this person, this Commonwealth of Pennsylvania, is that if it was named to a party in an action as plaintiff, was it given prior notice or notice, and did it consent to being named? I want to see some documentation to that. But if you don't raise that argument, if you don't dispute, then you waive it. There's a lot of rocks in that citation that you could take out and throw in their gearbox. They just might realize that, oh, if we continue here, this guy's going to, you know, they'll be reaching for a bottle of Imodium. They just might call up the police officer and say, hey, withdraw the paper, we can't deal with this guy. That has worked twice for me. I'm going to make things as difficult as possible. After all, we have an adversary system. So, what else do I want to mention today? Yeah, getting back to that affidavit. That magistrate, he won't even touch that affidavit or your interrogatory. Because if he touches it, then he accepts it, then he acknowledges it. So if he won't even touch your paperwork, that's a clue right there. So you see, attached to the interrogatory, I have a notice of response. And one thing I say in this notice of response is that if he fails to sign the affidavit and answer the questions, well, then he's going to be deemed incompetent. So I say, listen, you might as well recuse yourself right now. Let's take this to a magistrate that will honor their oath and will answer the questions. And then that would be like Groundhog Day, that movie Groundhog Day, because then I'm going to go to that magistrate and I'm going to present the same affidavit and the same interrogatory. It could go on forever. See, on this ship in dry dock, this foreign vessel, the Constitution does not apply. Therefore, their oath does not apply. I want him to make confession that he's going to honor his oath while he's presiding over this case, because I want to get his feet back on land. I mean, these people have a lot of balls that they want to create an environment where the Constitution doesn't apply, but yet they have the balls that they insist to be called with a title of nobility, Your Honor. And it's a shame with these magistrates. They drown the poor guy in a bucket full of egocentric hype. 150 times a day, they keep calling the guy, Your Honor, Your Honor, Your Honor. After a while, he starts believing the bullshit. It's like some spoiled little brat, little Johnny, where his parents keep telling him, oh, Johnny, you're special. And after a while, Johnny starts believing that he is special. That's why he continues to be a bully. Okay, so I'm just checking my notes here, what I want to mention. Oh, another thing, too. You can tell him, I says, I want to subpoena the police officer as a witness. Now, they might tell you, well, he's going to appear automatically. I says, nope. See, I want to subpoena him as a witness because then I could challenge his competency, because without a competent witness, there is no case. And tell him he better bring his attorney. Because some of the questions I have, he might have to invoke the fifth, because he'll be incriminating himself. Right there, if this police officer is notified that he's going to be named as a witness, and that I'm going to challenge his competency, he says, hey, I don't want to be involved in this. He has discretion. The police officer could just withdraw the case, and then they're done. In fact, what I do is a tactical swing move. I'll tell the magistrate, yeah, I have several subpoenas that I want to be served, but I'm going to come back tomorrow and do that. But I tell him ahead of time, I says, I want to subpoena the police officer because I want to challenge his competency. I want to subpoena the plaintiff here, this person, the Commonwealth of Pennsylvania, because I want to find out if it was notified that it was named as a party to an action and it consented. I want to see the paperwork that it consented. And I'm tell the magistrate, I'm going to subpoena you because I'm going to challenge your competency. After all, you refused to sign this affidavit and you refused to answer the interrogatory. Yeah, he says, I'm going to come back. See, I'm going to give him time to think about it. Maybe make some phone calls. They just might make the case disappear. Hey, whatever it takes. To me, these are racketeers. And they prey upon your ignorance. They anticipate that you're dumb and stupid. See, normally they allow the police officer not only to make appearance as a witness, but they allow him to prosecute the case, right, to raise objections. The only way the police officer can stand in as prosecutor is that you have to grant him permission by not disputing, by not objecting. And that's how they exploit your ignorance. Now in the PA code, they mentioned that a police officer may act as prosecutor. But that statement they have in the PA code is predicated upon the position that the motorist is too dumb and stupid to object, and they know that they can count on their buddies, the lawyers, not to even go there. You're supposed to have a separation of powers. Why does the police officer have to make appearance? Well, when he files the paperwork, at that point in time, it's hearsay. It's only an allegation. So the police officer has to make appearance and basically tell the court, hey, I wrote that. And then his job is done. He can go back to the police station, sit in the audience, or go back to the coffee shop and have a donut. But what does the magistrate do? When the hearing starts, he sets the citation aside like it doesn't even exist, because he knows it's fraudulent. And then he allows the police officer to take the stand and present a fresh oral narrative that's all juicy, like a spin doctor. You've got to object to that. The police officer had his chance to speak and what's in the citation. Because that's it. He's done. There's a completeness clause in that citation. Now I realize the citation is there's only a small space where the police officer can write some stuff. Okay. But after the citation is filled out, police officer has to go back to the barracks or the police station and fill out an incident report. That's required. So when things are still fresh in his mind, then he could, write in more detail. And then he could take that incident report, attach it to the citation before he files it. So he had all the opportunity before the hearing to, say what he needed to say. But if he was to attach a copy of the incident report to the citation before he files, then that means that he has to go send me a copy, because this way here I could prepare a meaningful defense. He has to make disclosure ahead of time. Like I said, the magistrate, to me, he knows that this citation is fraudulent, it's counterfeit. That's why he needs the officer to go on the stand and present a fresh oral narrative, like the spin doctor, all nice and juicy. He said, no. Objection. I said, whatever he says here, he's like springing it upon me at this last minute. How can I have a meaningful defense if he's like sucker punching me with this information right now during the hearing? I didn't know this. So you have to object. I said, there's no reason why this officer has to go give a fresh account. You just got to tell the magistrate, hey, we have to stick to the original narrative, what he wrote on the citation. That's it. He waived his standing to add anything extra because he had plenty of time to, attach an amendment to that citation. So you hire an attorney. Are they gonna object to this police officer, taking a stand and giving a fresh narrative? No, because to me they know that the paperwork, that citation is bogus, counterfeit. This is why they want to make sure the magistrate sets it aside, like it didn't even exist. They're all part of the money club. Well, there's a few other things I got to talk about, like this Title 75. Hey, the vehicle code does not apply. If you're a motorist, the vehicle code does not apply to you. You're not issued a copy, but a police officer is issued a copy. That's his field manual, his referencing guide. I did an exhaustive research to the evolution and development of the vehicle code, like reverse engineering. And I was surprised what I found out. I'll have to talk about that in another video. I try and keep my videos to about a half hour, a little more, a little less. Alright, until the next video, take time to think about what I said. If you have any comments, leave them below. If any police officer or attorney happens to be watching this video, I welcome your input. Leave a comment on the condition that you identify yourself. Don't hide behind some fake profile. Alright, till next video.